Good morning, good afternoon, or good evening. On behalf of the Department of Law, North-South University, it is my privilege and pleasure to welcome you all to this talk on constitutionalism in context by Professor David S. Law. Professor Law has edited a book very recently on this very subject. Before I hand over to Professor Law to talk on the book and on this topic, let me just say a few words. If an alien were to descend on the planet Earth and try to read about constitutions and comparative constitutional law or comparative constitutionalism, maybe that alien would think that the world is just about a handful of countries, or is the world's constitutionalism is about a handful of countries. Maybe it would be about the US, maybe the UK, maybe South Africa, maybe some other countries in Europe, maybe particularly Western Europe, maybe at best Hungary, maybe about India and some others, very few from the global South. Much of Asia, to my limited knowledge of constitutional law studies, is at all captured by much of the literature that we see on this subject. However, Professor Law's book is a very significant, I would say, departure from the trend in terms of the countries that the book studies, in terms of the richness of its subject, and not just in terms of geographical coverage, also in terms of the topics that it studies. I think it's quite broad, it's quite innovative, and I'm quite sure that it's going to be studied. As I understand from reading parts of the book, I haven't been able to go through the entire text of the book yet, which I'm sure I'll do in coming months. I can see that Professor Law has presented a very rich breadth of jurisdictions in a very comprehensive way. And he, as I understand it, asks us, or sort of makes a call, that in studying constitutionalism, we should not be limited to just a few jurisdictions or a few traditional hot topics. And he talks about pedagogical pluralism. With that, I formally invite Professor Law to deliver his talk. I look forward to his talk and also to your questions. Professor Law, over to you.
Thank you so much, Professor Rizwan. It was really an honor. I have to confess that I'm not sure why my video is turned off. Let me see if there's something I can do here. If not, I think when I end the screen sharing, can you all see the slide right now?
Yes.
Sorry, I think I see where the problem is. Oh, goodness. It's very tricky to do some of these Zoom things sometimes. There we go. Okay, I'm back. It is really an honor, and I'm sorry I can't join you in person, but maybe we can rectify that someday. I couldn't ask for a better or more generous or more insightful introduction from a more distinguished scholar. So, again, my thanks to Professor Rizwan for the opportunity to talk about this book, Constitutionalism in Context. This is a timely talk because the book has been just released in paperback. So that is, I think, a significant lowering, given that this book had the Global South and non-American audiences in mind. I'm very glad the book has been lowered to about $50 US, 40 if you use the discount, which I'm happy to share with Professor Rizwan. He will have this flyer. So for anyone who wants to get the book, it should be closer to $40 US, which is, for what you're getting, over 600 pages, not too bad, right? Something that works as a textbook. So by the way, what you're seeing in the background here is, this is the original illustration on which the book is based, Howard Chandler Christie's Scene at the Signing of the US Constitution. If you're wondering what is that image, that will be in my background. And that image is a modification of this painting from 1940, very famous, hangs in the US Capitol, where everyone except James Madison is replaced with representatives from the countries that are covered in the book. So if you like trivia hunts or trivia challenges, you can see how many of the people you can identify. Not all of them are historical figures, but many of them are. And the idea here is that if you were to have a visual representation of constitutionalism that reflects the diversity of the world, it would look a lot more like this. It would be half Asian, at least half Asian. Then it would be maybe a quarter black, a quarter white. And it would have heavy representation of Asia, the global south. A quarter would be drawn from the Muslim world, and that's precisely what we have in this book. And all of that is very unusual by the standards of this particular field. Precisely as your professor said, the traditional focus of the field is what we might call an unofficial canon. These are what Professor Herschel has called the usual suspects. Usually in this field, we focus on judicial enforcement of rights, and sometimes judicial allocation of governmental powers. That could be separation of powers. It could be federalism, depending on the country. And it's usually studied through the prism of landmark judicial rulings from English-speaking common law and or Western European liberal democracies. So the jurisdictions would be precisely as your professor said, the US, Canada, South Africa, Israel, Germany, India, increasingly maybe Colombia, but not a lot of representation of Asia. India is sort of obligatory for a couple of issues. Occasionally you might see a book refer to Japan, but most of Asia is missing. Now, why is it that the field has become hung up on these jurisdictions and these topics? So when we focus on this, in this field, because we're supposed to cover, something like 200 jurisdictions, we just have to cut down. And so the question is, how do we pick what to focus on? And for decades, the focus has been on these jurisdictions and these topics. And the question is why? So I would submit that the reason we end up constantly looking at these jurisdictions and these topics is because whether we realize it or not, we are acting on a particular conception of the field, right? Teaching forces us, or putting together a book or a syllabus, forces us to boil the field down to what we think is at the core, what is most important. And so we cannot put together a handbook or a textbook or even a syllabus without acting on some understanding of what the field is. And by conceptualization or understanding of the field, I mean answers to the questions, these basic questions: what should we cover and why? When we can only have a couple of weeks, hours a week for one semester, it forces us to be very ruthless in paring the subject matter down to what we consider central, what we consider the core of the field. And when we pare down to judicial review and enforcement of rights in a dozen or so liberal democracies in the West, we're acting on a particular understanding of the field. Now, that is a valid understanding, but the problem is we too rarely think about what that underlying conceptualization is. We don't think about it critically. We don't think about what the alternatives are. And because we don't think critically about what we're doing and what the alternatives are, we tend not to make the choice in a thoughtful way. And that's problematic. So thinking about the way teaching is done in this field and the way scholarship is done, it's possible to tease out or infer a number of conceptualizations, competing conceptualizations of the field. And I label them instrumentalism, tourism, immersion, abstraction, and representation. The first two of these, instrumentalism and tourism, are very common in teaching materials. The next two, immersion and abstraction, or as I call them, are very common in scholarship. And the fifth, what I call the representation approach, isn't as common, but deserves more attention, and particularly for audiences that are currently underserved. So let me explain what I mean by these terms. So the visual metaphor for instrumentalism would be skimming the cream off the top. You have this delicious jug of milk, but you actually don't want all of it. You just want the creamy layer, to borrow a metaphor from Indian constitutional law. You're really just interested in the part that is useful to you, right? I'll give you another metaphor. You go to other countries not because you want to and not because you want to learn how they eat or eat what they eat, but because you make roast beef sandwiches and you want to see how other countries make roast beef sandwiches so you can make tastier roast beef sandwiches. And so you might go to France and discover that they put mustard on theirs. Well, that's a great idea. Or you go to Germany and discover they put sauerkraut on their roast beef sandwiches. That's great. But you wouldn't be interested in French cuisine per se, or German cuisine per se. It's a very selective tour, just of the places that offer this thing you're interested in, and you're just interested in that one thing, okay? So you might skip India entirely because roast beef is not a big thing in India, right? Not because you think India is unimportant, but just because it doesn't offer the thing that you're interested in. So there's an analogous approach to comparative constitutional law, and that is to go around to other jurisdictions, just extracting what is useful to you, what relates to your own pre-existing interests and preoccupations. You're not interested in seeing the world through their eyes. You're not interested in what their problems are or what they consider important. You're just interested in how they deal with the things that you consider important. So, for example, scholars around the world might look to Germany. That's a common case, but they might look to Germany if they're being instrumentalist for very different reasons. So in the United States, where abortion is a huge political issue, they might look to the German abortion decisions. But they might not have any interest in the South Korea's cases. They might not have any interest in Germany's cases on the banning of political parties, because the US Supreme Court doesn't ban political parties. And they also might not have any interest in German cases on reunification, because the United States has never had to face a reunification situation. Now, South Korea might do the opposite. In South Korea, abortion is not a big political issue. So the South Koreans might study Germany, but not for abortion, but they might be very interested in the banning of political parties because their constitutional court bans political parties. And they would also be very interested in anything having to do with reunification, because just as East and West Germany reunited, the thought is that one day North and South Korea might reunite. So first, instrumentalism means we'll be very selective about what jurisdictions we look at. It'll be just the ones that offer what we're interested in. So if we're a liberal democracy with judicial review, we'll only look at other liberal democracies with judicial review. And even when we look at the same jurisdiction, say Germany, we'll pick and choose the parts that relate to our domestic debate. Now, does this yield a representative view or understanding of the world? It absolutely does not. It leads to an unrepresentative sample of the world driven by the end user's professional needs. Now, that's fine as long as you're meeting the needs of your audience, but it does mean you're not conveying a sense of what the world is like generally, what constitutionalism is like generally. And if we follow this approach, what we end up with are teaching materials in the teaching world. We end up with teaching materials that are very tailored to the interests and needs of a very specific audience. So, for example, the main case books in comparative constitutional law produced in the US assume an American readership interested in issues that are important to Americans. That yields books that are great for an American audience, but don't work well for other audiences. So if you try to teach out of those books in Taiwan or South Korea, you'll find they spend a lot of time on issues that the Taiwanese or the South Koreans or the Bangladeshis are not super interested in. And the book will also skip over issues that would be of much greater interest to a Korean or Taiwanese or Bangladeshi audience, okay? And you might find that the books generated by these big markets like the United States or Germany don't work very well if they follow this approach, because this approach is so tailored to the needs of a specific audience. Okay, next approach then, if not instrumentalism, what else is possible? We might call the second approach tourism. This is also very common in comparative constitutional law. And the metaphor here is, imagine you are on a tour of Europe, but you only have 7 days to see Europe. And so you will just see the things that everybody sees, the things that are most popular. So you'll see, does anyone recognize this building on the left? This is, I'll give you a hint, it's a politically unstable country in a severe economic crisis? That's right, it's the United Kingdom. Okay, so that's a big one from the UK, Parliament buildings, and then that's the Eiffel Tower on the right. So you would get a version of Europe that is the tourism greatest hits. There's a similar approach in comparative constitutional law, which is that you go around the world focusing on the most widely read, best known cases. Those are likely to be materials. Those are likely to be judicial rulings, and they're likely to be, in particular, judicial rulings on rights issues, from big controversial aggressive rulings from, again, the usual suspects. And so this approach really is deliberately focusing on the usual suspects precisely because they're so popular. We study the popular jurisdictions, the popular materials, because they're popular. One could go a step further and say, oh, we don't study them just because they're popular. We study the materials that are the best, or the most important, or the most interesting, right? But again, those will be selected from a very particular perspective, and they're likely to look a lot like the jurisdictions and materials that we already study. And so the effect, whether intentional or de facto, is to canonize the usual suspects. The things we usually study become the things that we think that we're supposed to study because they're so widely studied and other people read them. So again, the problem there is if you go see the world as a tourist, you don't really get a sense of the full world. You get a sense of the things that are most popular with tourists, but you don't get a representative picture of the world. You don't get a representative picture of how constitutionalism looks. You just get a sense of how it looks in the places that people are most familiar with. Now, a very different approach is immersion. The image here is Clifford. This is anyone recognize what this is? I don't know if people are able to speak up. Feel free to raise your hand, or if you think you know what this is. Anyone? So this is a cockfight. And in particular, I believe it to be a Balinese cockfight in homage to Clifford Geertz' Notes on a Balinese Cockfight. So why this image? So Geertz was an ethnographer, an anthropologist and an ethnographer. For him, he was interested in understanding what is important to the people in a particular place. What do they do and why do they do it? He wanted to experience and see the world through the eyes of the locals. Okay, this is very different, obviously, from tourism or instrumentalism. Rather than going to Paris to see the Eiffel Tower or London to see Big Ben, the idea is to immerse yourself in France and to try to see the world through the eyes of someone who is French or is British. And if you actually are French or are British, the chances you will go to the Eiffel Tower are basically zero. That's not what you're going to do, right? You're not going to go to Big Ben. And so there's a similar approach to the study of comparative constitutional law, which is that the goal is to try to think or work like a lawyer in another jurisdiction, to see the world through the eyes of the other, to immerse yourself, to put that jurisdiction under the microscope. So there is a big trade-off. So that means you go very deep. But when you go very deep, that tends to mean you can't go as broad. There is an inherent trade-off between depth and breadth. And if we go deep to get a deep contextual understanding of a particular place, say Bali, it means we're not studying other places. So there is an opportunity cost to an immersive approach. So a drawback here, an advantage is, of course, we get rich, deep contextual understanding. A drawback is that we focus on an unrepresentative, narrow sample, and not just an unrepresentative, very narrow sample, but in all likelihood, the countries that will get studied under this approach are the countries that people know best, and that means the countries that they're trained in, which means the same English-speaking liberal democracy countries over and over, right? So the consequence may be that we get deeper knowledge of these jurisdictions, but they're the same jurisdictions we already know about. And we see this approach a lot in traditional comparative constitutional law, and indeed comparative law scholarship, which tends to focus at depth on a relatively small number of jurisdictions, what we call small n comparison, right? People will talk about 2 or 3 or maybe just 1 jurisdiction. Now, the opposite, which is also common, the opposite approach from immersion, also common in scholarship, is what we might call the abstraction approach. And here the idea is, rather than zooming in really close, is to back far, far away, the bird's eye view, indeed the satellite's eye view, to the point where we see big picture patterns, okay? We can see sort of landmass groupings and broad distinctions, and we can see things that look like they're together and things that look like they're apart, not up close, but from a great distance. There is an analogous approach in comparative constitutional law, again, which is to approach the subject from a tremendous level of abstraction, to identify principle, patterns, methods, categories that can be applied broadly. They're not deep, but they can be applied broadly, right? Because we've taken such an abstract perspective, we've taken a step back, we see things that are broadly true, but they're not deeply true. So some examples of work in this vein would be thinking about legal traditions or families or cultures. We know that if we look at Sweden up close and Norway up close and Denmark up close, they're quite different from each other. But if we back away, we can talk about the Scandinavian legal tradition or legal family, right? The same with the civil law. We know civil law jurisdictions vary a lot, but if we really back up, they might look like they have broad similarities compared to common law jurisdictions. Likewise, we could focus on similarities, right? Generic constitutional law, balancing, proportionality, means end analysis, right? These are things that, although they're done differently from country to country, at some broad level of abstraction, they're kind of similar. Now, this works reasonably well for people who maybe need a little bit of knowledge about a lot of different places. But it is, again, and it's a lot of breadth, but it's at the expense of depth. And the criticism here would be that you learn so little about so many places that in the end, you don't really learn about any particular place. This kind of approach is good for scholars. It might train you to make comparisons, to look for similarities and broad differences, but it doesn't actually equip you to be a lawyer in any particular place. You just don't have enough detail, okay? And arguably some version of this already happens within federal systems. For example, in a US law school, we never teach just in the quote unquote leading schools. Here in Virginia, we don't just teach the contract law of Virginia or the tort law of Virginia or the criminal law of Virginia. We instead try to teach criminal law principles and doctrines that are generally true across all 50 states. And when there are major differences, we explain those differences. Likewise, in the European Union, there's this thing called, the principles common to the member states. That doesn't mean that all European countries have the same public law, but it means that there is a level of abstraction at which they share certain things in common. Okay, so this is actually a widely practiced approach in the scholarly literature, not so common in teaching materials, but quite common in scholarship. Now, there is another possibility, which we don't see much so far in either teaching materials or scholarly materials, and I call that the representation approach. Can anyone tell me what this building is? This is the visual metaphor here. Anyone have any idea? I don't know if people want to raise their hands or put an answer in the chat.
It's the US Supreme Court, right, David?
It is not the US Supreme Court. That's not a bad guess. I mean, the problem with the US is because it's such a young country, they try to make everything look old to make up for the lack of history, right? So everything is neoclassical. I mean, it is a big, impressive building with flags in the neoclassical style, but it doesn't help very much. I'll give you a hint. This is in New York City. Anyone? It's very popular with tourists. It is a major tourist attraction. One of the top things a tourist would see in New York City. Any guesses? Everyone's stumped. Professor, want to try one more time? You would, if you had 5 days in New York, you would almost certainly go to this building. This is the Metropolitan Museum of Art. Okay, so for many people, I could have put up any number of museums, but I tried to think of, what is the most famous museum in this country? I could have put up the Louvre, but that would have been too easy, right? Because of the pyramid. So this is the Metropolitan Museum of Art. Now, what does the Metropolitan Museum of Art possibly have to do with comparative constitutional law? So museum curators face a problem that is very similar to professors of comparative law and comparative constitutional law. They have too many things in the collection to show you, and they won't all fit in the building. The typical museum, including the Met, can only show around 2% of its entire collection at any given time. And so museums face an intense challenge of curation. What will they put on? What 2% will they pick to show you? That's a very small fraction, right? Just like we can barely teach American constitutional law in 2 semesters in this country. You can probably barely cover Bangladeshi constitutional law in 1 semester. And now we're saying, well, cut the amount of class time in half and multiply the number of jurisdictions by 200 and now teach it, right? It's impossible. So what do museums do? Museums curate, meaning they don't just pick the things that they think people will find most, they most want to see or most interesting or most popular, but they'll actually try to show you a sampling of all of their collections. So the Metropolitan Museum of Art won't just put out things from Egypt, right? It won't just put out things from China. It won't just put out, French Impressionists and German Expressionists. It won't just put out sculpture, photography. It will put on a little bit of everything to give you a flavor, a sense of what collections they have and what each of those collections is. Okay, so they're picking things. We could follow a similar approach in this field. We could try to expose people to just as the Met tries to expose people to all of its collections, we could try to expose people to the widest possible range of variation in constitutions and constitutionalism, right? Not just the liberal democracies with judicial review, but the ones that don't have judicial review, not just the countries in Europe, but also the countries in South Asia, East Asia, Southeast Asia, Africa, Latin America, right? Not just liberal democracies, but maybe some illiberal countries, maybe some semi-authoritarian regimes. Constitutions are now adopted by every country in the world. As a result, they're not always used the way they were in the late 18th century, right? And because they're now adopted by a much wider range of countries and put to a much wider range of uses, the field itself has become much more diverse. Constitutionalism itself has become much more diverse. We no longer live in a world where there's one type of constitutionalism, and it's the kind you saw in France and Poland and the United States in the 1780s, okay? And so a different approach to the field would be, well, we should try to show people all of the things that are in the collection. At least we can't show them everything, but let's show a sampling. So the idea here would be a highly curated sample selected to showcase as much variation as possible, substantive, geographical, ethnic, population, religion, every variable you could, socioeconomics, region, everything you can think of. And the idea here is to deliberately, for intellectual and substantive reasons, to expose people to diversity and pluralism and to approach the selection of materials in the spirit of pluralism and equality, right? Now, so this is intermediate in terms of it doesn't go super broad and it doesn't go super deep, but it is possible to get more traction, to show people more of the world in fewer cases by being very careful about the cases that we do select, and then taking the time to contextualize those cases. Now, what in the world of comparative constitutional law corresponds to such an approach? But up until now, not a whole lot, but this is the philosophy underlying the Constitutionalism and Context book, which again, I'm delighted to be able to talk about today. There are some very unusual things about this book. First, is it a handbook or is it a textbook? The answer is yes. It's really a handbook that incorporates features for teaching use. That's based partly on my experience and that of many other people, that instructors are often unhappy with the existing textbooks, and they end up using handbooks to teach because they like the quality of the scholarship, they like the quality of the contributions, the depth, but there are some sacrifices that are made when you teach out of a handbook. For example, sometimes the writing is very advanced. Sometimes things are not explained in a very thorough way for a beginner audience. There are no primary material excerpts. And so what we tried to do with this book was to say, this is a handbook, it works as a handbook, but we'll make it accessible and we'll incorporate features for teaching use, such as primary material excerpts and a supplement and a kind of teacher's manual, okay? Then also, the chapters are designed in a modular way. There are 3 chapters that introduce you to the field, but after that, you're in the case study chapters. And each chapter features a topic, plus a jurisdiction, plus a case study of the topic in the jurisdiction. That means that if you're a scholar, you can use the book as a reference on topics or on jurisdictions. And if you want depth, more depth on the jurisdiction, you go to the case study of how a topic works in that jurisdiction. If you want more depth on a topic, you have a case study of how that topic works in a particular jurisdiction. And if you want to teach a course, a traditional course by subject matter, you organize the chapters by subject matter. If you want to teach the course by region, again, Asia, the global south, the Muslim world, underrepresented, you can easily do that, because then instead you choose the chapters by jurisdiction rather than by topic, and you organize that way, okay? And so as a result, the book actually has two tables of contents, one organized by topic and one organized by region. And it also looks totally unlike any other general textbook or handbook in the field. Again, fully half, 10 of the 20 chapters, the case study chapters, are about Asian jurisdictions. A quarter of the jurisdictions, over half of the world's population is from Asia. Half of the chapters in this book are from Asia. A quarter of the world's population is Muslim. 1/4 of the case studies in this book are from majority Muslim jurisdictions. You will not find that in any book that is not specifically focused on the Muslim world. This is absolutely the first to do that. And of course, given the coverage of Latin America, Asia, the Muslim world, obviously you're looking at a book that has very heavy coverage of the global south. These are typically not the usual suspects. If you look at the introductory chapter on concepts and constitutionalism, constitutions and constitutionalism to introduce key concepts, China is used as a case study. I don't think I need to explain to anyone in the room how massively important China is geographically, politically, economically, militarily, and yet we refuse to study it. And one of the reasons we refuse to study it in this field is, I think there's, it's not a liberal democracy, and so we shouldn't study them, right? Because we want to be a good liberal democracy. To me, that's a bit like being a doctor and saying, we don't want to study sick people because we don't want to be sick. Let's only study healthy people. No, if that's what you're concerned about, if you don't want to be like China, then the number one thing you need to study is China, right? So this book leads with a case study of China. Then we go to Afghanistan, right? Using that as a case study of constitution making for divided societies. Then we move to Nepal, again, a jurisdiction we don't often see in the literature. Hungary, a little bit, but then Sudan, not so much. Taiwan, the Netherlands. The Netherlands is in the heart of Europe, obviously, and yet you don't see much discussion of it in comparative constitutional law because it does not have judicial review. And so it gets left out of the discussion. And because we leave out liberal democracies that don't have judicial review, it's easy to form the misimpression that democracies must have judicial review in order to be democratic, in order to be liberal, in order to protect rights. And it's simply not true. We have that impression because our case selection is so poor. We keep focusing on countries with judicial review, and we forget to study the ones that don't. Right. So I could run through the rest of the table of contents, but it's more and more of these jurisdictions: Argentina, Cyprus, Brazil, Indonesia, Iran, Turkey, Thailand, that you don't normally see in most of these books. A few of them you'll see. South Africa, yes. Hungary, a little bit. But again, most of these you just don't see much discussion of. Okay. And then because of the modular chapters, you can organize the book so that you have a unit on East Asia, a unit on South and Southeast Asia, one on the Middle East and Central Asia, Europe, Latin America, Africa. Again, this is all unusual for a book. So to conclude, the argument is not that we should pursue representation to the exclusion of other audiences. I've tried to be clear that each of the 5 models works for a particular audience. The problem is when we don't have a choice, or we don't realize we have a choice, and we're not thoughtful about whether we're picking the right approach for the audience that we are talking to, okay? There is no wrong choice among these 5 approaches, but there are choices that don't make sense for particular audiences. As long as we think in a thoughtful and informed and deliberate way about what we're doing and why, that's fine. Problem is when we just sleepwalk and do approaches that we inherited from our own teachers. We do instrumentalism because then we just talk about the cases we already know and the jurisdictions we already know. We do tourism because there's already a book that has that approach and it talks about things we already know, okay? So some of these approaches are easier to default into. Others are going to require more work and more resources be created, such as the representation model. That doesn't mean, again, the representation model is the right approach for everyone, but I do think it works better for a lot of audiences that have traditionally been underserved. And so as a result, the more approaches we can implement, the more pluralistic we can be, the better. So thank you very much for that. I always welcome thoughts on whether this typology is complete or comprehensible. I think these are the main approaches to the field, but again, there's not a lot that's been written on this. So I welcome any thoughts on what the models are, what factors should guide the choice among these models, and if there's anything more that should be said. And with that, I open things to questions, and thank you for listening.
Thank you, Professor Law, for your excellent talk. Let me put the first question to you from one of my esteemed colleagues, Mr. Nafiz Ahmed. His question is, by immersion, are you referring to something similar to what Matthew Kramer calls the simulative point of view?
Michael Kramer, you said?
Matthew Kramer.
Oh, Matthew Kramer. It might be. I'm not familiar with Matthew Kramer's work. Is he a legal scholar?
I think he works on constitutional law and also on legal theory, but not do I'm very familiar with his work. But that's what the question asks. So maybe we would ask for some supplementary comments from the colleague. Maybe we could move on to the next question.
Sure.
So I was wondering.
It sounds like it might be. I'm not sure.
Thank you, David. My question to you would be on Taiwan's example that the book covers, that if I understood it correctly, Taiwan has a sort of extreme or unusual culture of judicial review, that at times the court would not only say that a particular law is unconstitutional, it would also somehow direct the parliament that what that law should be. So am I right on that? And if that is the case, why it is so in your view in Taiwan? And what about the sort of a similar situation in other parts of Asia? Any thought on that? Thank you.
Yes, and so I think, thank you for bringing up the Taiwan case. Now, the Taiwan case really illustrates that under the right conditions, courts can be enormously powerful. Their power can far exceed what you see on paper, okay? Judicial power, I really think, is a function of context and politics at a particular place, particular moment, at a particular time, not so much necessarily about what's written down in the Constitution or what the court itself claims that it has the power to do. You're absolutely right. The Taiwanese Constitutional Court, during Taiwan's process of democratization in the late 1980s, wanted to accelerate the pace of democratization. And there was this constituent assembly that consisted of legislators who had only been elected once, 40 years earlier. And the court said that the body was unconstitutional and said that new elections needed to be held that would be more representative. And it indicated what kind of an electoral system would be considered constitutional. And the government, of course, did not have the power to, in order to fix the legislature, a constitutional amendment was necessary. The court didn't have the formal power to order a constitutional amendment, but it did say, here is what you need to do. You need to you have to add members of the legislature. They have to be elected at large. That will fix the problem. And that's precisely what the government did. Now, there's nothing to ever prevent any court from simply saying to the other branches, you should amend the Constitution this way or that way. But it wouldn't always succeed, right? So why did it succeed in the case of Taiwan? It did not succeed because the Taiwanese court had some formal power in the Constitution to propose constitutional amendments. Far from it, right? No court, as far as I know, has that power. I'm not aware of any examples. However, it was acting in an environment where the other institutions around it all had great democratic deficits, right? Yes, the court isn't elected, but neither were the other institutions because Taiwan was transitioning to democracy. So no one could really claim, oh, you're being undemocratic, number one. They couldn't criticize the court for being really undemocratic because they themselves didn't really have much of a democratic pedigree. And number two, and I think this is the crucial thing, courts are really like other political institutions in the following sense. If you have the support of the people, What can you not get away with, right? When the court proposed this solution and other Taiwanese politicians and political institutions realized that the court had popular support, of course the court's going to win. If you are dealing with a democratic environment, then ultimately whatever institution or person has the support of the people is going to prevail by definition. And it is perfectly possible in a particular environment for some period of time for the institution with the most popular support to be the courts. Now, you wouldn't expect that to be the case on a permanent basis because other institutions are elected and courts are not. So you would think that elected institutions and officials would be reflective of the popular will. But again, this was a period where Taiwan had not yet democratized. And so it was entirely plausible for the Taiwanese Constitutional Court to actually have more popular support than the so-called democratic institutions, the usual political institutions. And that's precisely what happened. And it's interesting too that as the other institutions have become more democratic, the Taiwanese Constitutional Court has become much less aggressive. And that also makes sense because now it cannot think, it does not assume that it has the people on its side as opposed to the institutions that are elected. Does that kind of cover the question?
Thank you. I'm sure it does. Now we have some further clarifications from Nafiz Ahmed. So yes. I'm just reading his comments. He says, he is a legal philosopher. By simulative point of view, Matthew refers to a point of view of a person who argues in a way that would lead one to believe that she has taken an internal point of view, within bracket, accepted towards a certain law without actually taking it. For example, someone teaching Roman law in 2022.
Yeah, so I think that's right. What I'm talking about, the internal perspective.
Thank you for that clarification. Now we have another question from one of our students, Taslim Bhuya Prantik. He asked, what is the purpose of constitutionalism within a neo-democracy?
Yes, so I think in new democracies, that is one of the few contexts where a particular form of liberal constitutionalism maybe can be helpful. And partly it depends on what you mean by constitutionalism. I'm going to assume for these purposes that we mean liberal democratic constitutionalism, and in particular with a role for courts in the form of judicial review. Okay. So let's think about the role of constitutions and the role of judicial review. Why do some countries need constitutions while others seem to do fine without them, right? The United Kingdom is a common example of a country that does fine without a written or codified constitution. The United Kingdom does fine because one of the big things that constitutions do, which is discussed in Albert Chen's chapter in this book, is they have to coordinate behavior, right? People have to understand what the ground rules are, and they have to understand how conflicts are resolved. Those are two of the major functions of constitutions in pretty much any society. If you're the British and you have been doing things, you're a well-established country that's been doing things a particular way with only incremental change for 1,000 years, do you really need a piece of paper to tell you what the ground rules are? Not really. Everybody kind of knows the ground rules. If you are a new democracy trying to make a break from authoritarianism or monarchy or sectarian rule or civil war or whatever, you may not have that kind of tradition to draw on where people just already know what the ground rules are without having to look them up on a piece of paper. And so first, one part of contemporary constitutionalism, the use of written constitutions, can be unusually helpful in new democracies precisely because constitutions are focal points. They draw attention, and so they are a good way of getting people to agree to ground rules, to broadly transmit understanding of what the ground rules are. Another part of constitutionalism that can frequently be helpful in new democracies, not a mandatory part, but a part that can be helpful, is judicial review. Why is judicial review helpful in new democracies? Again, there's going to be a lot of disagreement over ground rules, the rules of the game, how politics is conducted, what institutions have what power. Now, we could just let the institutions fight it out amongst themselves, but it can be helpful sometimes to have an institution that acts a bit like a referee. Now, referees are not perfect. They can be self-interested. They can make mistakes, but there are at least a couple of examples, South Korea and Taiwan come to mind, of constitutional courts helping to ease the transition to democracy or helping to consolidate new regimes. So I do think that certain aspects of constitutionalism are unusually helpful for new democracies. The use of written constitutions itself, and potentially also judicial review. Now, do established democracies need them? Look at the United Kingdom. Again, no judicial review in the sense of invalidation of legislation, no codified constitution, and it works more or less fine, precisely because they've been doing it for so long, and so the rules are understood. Does that answer the question?
I think it does. Thank you, David. Now, the next question that I have for you is, do you see any trend in or tendency of using international law in interpreting the provisions of national constitution in maybe Asia or in Africa?
On the whole, I think there is a trend. It's more obvious in newer states, fragile states, post-conflict states, developing states, which kind of makes sense because those are the states that are most dependent on the international community and the international legal regime, right? So if South Sudan, for example, gains independence with the help of the international community, if Timor-Leste gains independence with the help of the international community, if the civil war in Yemen ends with the help of the international community, the political actors in that jurisdiction will be heavily indebted to international actors, the international community, and will be much more likely to be aggressive about incorporating international law. You look at the other end of the spectrum, a country like the United States, a country like China, these are big, powerful countries. Do they pay as much attention to what international courts and international law have to say? Maybe not, because they can afford to ignore it. So, those of us who live in smaller countries, I'm originally from Canada, right? Canada is a country that takes international law pretty seriously because it can't rely on guns and bombs and planes to get its way, right? It's a medium-sized power at best, and its peaceful existence relies on a peaceful international order, right? So, smaller countries, mid-sized countries, newer countries, post-conflict states, I think all these countries are likely to be more invested in the international legal system.
Thank you, David.
Does that make sense?
Yeah, I think it does. Now, let's say, taking that analogy of a curator, if you were a curator with much bigger space to showcase constitutionalism, what are the jurisdictions or topics that perhaps you would have included if you were not constrained by the practicalities of putting them together in a book?
Yes. And the practicalities are, if this book were any longer, if I included more chapters, the price would have been higher, significantly higher. The way publishers work is up to a certain number of pages, you have a certain number of folios, and the book physically distributed a particular way. If you go much over 600 pages, the price goes up exponentially, right? I wish there were more coverage of Africa, for one thing. I would have loved a chapter on Egypt, to find some topic that works for Egypt, because that is a historically rich country. It is sort of positioned between the Arab world and Africa, right? I would have wanted more coverage of Africa generally. I think a great chapter could have been written on Liberia and the experience of post-colonialism. There's no chapter specifically about the post-colonial constitutional experience and the effects of colonialism on constitutionalism. I think that would have been great. It would have meant more coverage of the global South, of Africa, of a country we rarely hear about and a topic we rarely see. I would have liked, I'd hoped, I tried to get a chapter on Iraq. That did not work out, but that would have been a chapter about, this idea of imposed constitutionalism. I'd love to have more coverage of Latin America, even more coverage of the global South. There's no chapter on women's rights or gender issues. There is a chapter on LGBTQ rights. That's not quite the same. People have asked me, why isn't there a chapter on women's rights, which are, a very powerful post-war phenomenon? The answer is there isn't a reason. It was no space for it. Something else would have had to come out. But that was on my wish list as well. Yeah, that's a couple. I think maybe these days I'd want to put something in there about the idea of authoritarian constitutionalism as an attractive model. We do see China trying to not just influence the pocketbook, but to try to defend its system on normative grounds and to encourage the spread of its system. And I think there's something there worth discussing from a critical perspective.
Thank you.
But I'm open to more suggestions. If there are more things on the wish list, let me know. A country like Bangladesh is also, certainly a potential addition to the book because it's something that it's accessible to English speakers, so there's no linguistic excuse. There's a lot going on in Bangladesh that people are not. Oh, and the Philippines. That's another one. I do not understand why there's so little coverage of the Philippines. Massive country, huge population, active constitutionalism, lively constitutional politics, no language barrier, and yet when's the last time you read about the Philippines? Hard to understand.
Yeah,
not right. And even in the U.S., it's amazing that this is a former, U.S. Colony, basically, and the Americans don't even study it. What's the excuse? I can't think of any.
Except for some isolated chapters, maybe not too much on the Philippines.
Really just a few isolated things here and there. You have to actively look for it. I mean, I'm quite happy I was able to get something on Cyprus, something on Iran. These are not easy. These are not easy jurisdictions to cover. But yeah, I mean, the Philippines is high on my list. Egypt is high on my list. Liberia, something more in Latin America, more of the South Asian Muslim world. Yeah, all of these things would be great to include.
Thank you, David.
Maybe, I don't know if it should be a second edition or a different book. I don't know what it should be, but.
Thanks. Now, the next question would be, if one were to take a functionalist approach, could there be some benefits of taking an instrumentalist approach of teaching comparative constitutional law?
There is, if you are faced with a particular audience, right? So, for example, in the 2000s, when the Rehnquist Court, the U.S. Supreme Court, still had a lot of justices, both conservative and liberal, who believed in citing foreign law. Then it made sense, if you were going to be a U.S. constitutional lawyer, to learn about the kinds of cases and materials and jurisdictions that might be relevant to, interesting to the justices. So there was a time and a place where I think instrumentalism made sense, right? U.S. law school classrooms where the course is being taught to constitutional litigators. I'm not sure that's still the case now in the United States, but it's certainly still the case in a place like South Africa, where the South African Constitution explicitly endorses and authorizes the use of comparative law and international law in constitutional adjudication. I think their instrumentalism is always a live approach, right? Because the court is telling you we're permitted, indeed even obligated, to consider international law. So you absolutely, as part of your legal training, you should be looking at that. The United States is very different, where you have an ecosystem where it's, much more inward looking. Clerks, lawyers, judges are not expected to cite foreign law. Sometimes they're criticized for doing so. They don't get comparative legal training. And so the irony is that the instrumentalist approach is so popular in the US, and yet instrumentalism in the year 2022 doesn't make a lot of sense for US lawyers. It does make sense, maybe you could adopt an approach of training scholars, right? You just assume you're not going to use comparative law as a lawyer, you're going to use it as a scholar. And then, but if that's the case, I think the representation approach is actually in many ways better, because as a scholar, you want to understand more of the phenomenon.
Thank you, David. Now, I guess this would be our last question. So, as you have, I think, written in your chapter that perhaps there is only the Central European University where there is a specialized comparative constitutional law, LLM.
Oh, you read so closely, you read into the footnotes.
But apart from that, it's not a subject that's only studied by us, the law students. We are sure that it can be studied by political scientists, by other cognate disciplines, as you call them. So
Yes.
any thought on their approach to the subject, or if they were to read your book, how should they approach it? What is it for them? Thank you.
So I'm really glad you asked that. That's a great closing question. When I created this book, my guiding star was thinking back to when I was in political science graduate school and I was interested in courts and constitutionalism. What kind of book do I wish existed, right? And so, I think about half of the chapters are authored or co-authored by someone with a social science background, like a non-law background. A lot of political scientists, but also, religious studies scholars, and a sociologist, a couple of sociologists here and there. And you see there's also this debate that is discussed a bit in the introduction about, or the preface, the introduction about what the field should call itself. Some people, like Ron Herschel, argue for constitutional studies because that takes the emphasis off law. It takes law out of the title completely and emphasizes the extent to which this needs to be an interdisciplinary undertaking. I think one of the reasons that this is such a, those of you, I think, who are in the room, you have an interest in comparative constitutional law. I'm here to remind and reassure you that this is a terrific field, a dynamic growing field. And one of the reasons it is dynamic and growing is because it is a number of disciplines meeting together to study a wide range of jurisdictions. And so the variety of jurisdictions is great and appealing. It means you have the whole world to work on, but it also means that you have this broad range of tools. And we have been fortunate in this field that during the revival of this field, starting in the late 1990s, two groups came together. Traditional constitutional law scholars who are interested in what the courts were doing in terms of citing foreign law, and social scientists who were just thinking about places, other courts, constitutions, other places as a source of data, and they began talking to each other. And so the current version of the field that you see is very tolerant of a very broad range of approaches. And that includes interdisciplinary approaches. So there is not just an opening, but a need for political scientists, sociologists, anthropologists, economists to participate in the study of constitutionalism.
Thank you, David, for that excellent answer, and of course, for the excellent talk. Have a good day.
Thank you for the opportunity. It's been an honor. Thank you so much for having me. And I will share the flyer for the book